again, welcome everyone. Please start putting in your questions, any questions you may have around emergency care, legal aspects of emergency care. Put them in the chat section or in the Q&A section, and we'll be kicking off by just answering the question. So thank you, Paul Mutua has put in a question. Sheila's put in a question. So we'll discuss these questions. We have health law expert, Maurice Oduor, who will be joining us. So please put in your questions so that we can go through all the questions in this timeline. Yeah, just waiting for Maurice to join in. So welcome to our monthly CME session around emergency care. This week, by the way, on 27th of May is Emergency Medicine Day. And we'll be celebrating all emergency healthcare workers on this week. And so you should be celebrating yourselves and getting some videos done and celebrate emergency healthcare workers. So this topic started off as this topic started off. I'm seeing your questions, so good. Thank you for putting up all the questions. This topic started off as a WhatsApp discussion in our emergency care group, and where people are discussing about the legal aspects, different aspects of emergency care. And so we thought it's important to have this topic before discussed, and we've had it before as part of our CME series when we used to have physical CME series. So good to recap it, and we'll go through some of the questions. So feel free to just check your questions in the Q&A section, in the chat section. So just waiting for Maurice to join in. I think it's just running a bit behind. So I'm seeing very good questions. Okay, evening, Yuka Beth. Yes, what else am I seeing in the chat? So we have 3 questions so far. Declining minors when parents decline for emergency procedures for kids. Next of kin discussions, indemnity cover. I need to find out what that one's about. All right. And we'll hope to be discussing a lot of this evening. Dr. Shah. Maurice is joining shortly. Thank you very much. What's the point? Maurice is joining. Thank you. What's point to do limit care in ICU patient? Okay, good. So let's take this opportunity to just take all our questions. Good. Put them in the chat or in the Q&A section. Yes, so that as any question you may have around the legal aspects of emergency care, just put them in the chat or in the Q&A section. Maurice, and we'll start as soon as Maurice joins, which should be in the next few minutes or minute or two. So let's take this opportunity to put your questions. When a patient is a minor, just don't say, aha, okay, good. So I see similar questions coming up. Saying this is something clearly that's happening. Evening, everyone. Yes, so just type in your questions in the chat or in the Maurice. I see Maurice has joined. Hi, Maurice. Can you hear us?
Yes, I can hear you. I can hear you.
Welcome. Yes, we can hear you loud and clear. Thank you for taking your time to join us this evening. You have an excited group of emergency healthcare providers who are trying to stay out of jail. So we thought we'd come and ask the experts the questions. So maybe it's conversational, as I said. We're not having any slides or anything, so just a discussion, and I will be reading all the questions, and then you can maybe take us through a discussion on that. Maybe as a start, you can introduce yourself so that we know. Yes.
All right. Thank you very much, Dr. Washira. And thank you for your members for giving me this opportunity. Allow me to apologize first for logging in late, this technology thing. I was logging in and then Zoom decides this is the time it needs to update itself. My name is Maurice Oduor. I am an advocate of the High Court of Kenya, but more importantly, I teach at Moi University School of Law. And again, most importantly, is that I teach and research and publish in the area of health law, which is has been my interest in the last, let's say, 5, 6, 7 or so years. So that's where I am. Thank you.
Awesome. Thank you very much, Moise. And so, yeah, so if you're going to jail, just go look for Moise as a healthcare provider. He's the one who knows most about healthcare law. All right. So, a common question that actually has just popped up right now, and I've seen a couple of people asking is, what do we do? So, if the patient, a child comes in or a minor, so anyone below 18, and we need to do an emergency procedure on them and the parents decline. What are we supposed to do?
Okay. That's an interesting one. Now, when it comes to children, the rule is this. The guiding legislation is something known as the Children's Act. And under the Children's Act, there are two fundamental principles that apply in the context of children. One is that the best interest of the child principle. And number two is what is known as the principle of survival of the child. And the third one is the right to life. So where it is an emergency situation and a parent decides for one reason or another, because there are many reasons. One that comes to mind is this Shakahola business and all that.
Yes.
Religion, etc., etc. And they tell
Yes.
you, no, you can't operate on this child, and so on. The law allows you to make that determination. What is the best interest of the child at that particular moment? And remember, you as a specialist, you are the one who has the better information in terms of the consequences of non-intervention.
Yes.
The parent is just a lay person. They don't know, they may not necessarily have the best information in terms of the consequences of non-intervention. So on your part as a specialist, you look at the situation, what is the best interest of the child? If you don't intervene, what is likely to happen to the child? And the law will actually cover you if you undertake those kinds of procedures. Remember also, under the Constitution, there's an obligation to provide emergency care. And under the Health Act, it's actually an offense to fail to provide an emergency care when it is needed. And so where a parent decides for one reason or another, I think there are many rules, many permutations that will allow you to intervene under the circumstances.
Okay, so that's good to know. So at least then, as long as the outcomes or the decision favors the child, then
Yes.
We should be proceeding with the intervention, which is good to know, because I think most of us are normally quite scared, because I mean, we always feel that the parent is the next of kin and they're the ones who are making the decision. But it's good to know that there are actually laws, as you say, the Children's Act, the Health Act, all that there to protect us. So another question that's coming up that I've seen is, now, are we allowed to withdraw care? So the question actually, so with the limited amount of critical care services in the country, and the absence of, there are actually two questions here. So for example, person comes in and they've been in a severe traffic accident. We put them on a machine, but we know they're brain dead, but their heart is beating, and so they're not dead, for lack of a better word. So the first question is, can we legally get them off the machine if we determine that they are brain dead and there's nothing we can do about the situation? Despite the fact that the heart is beating, can we get them off the machine?
Good question. Now, here's the thing. As far as the law is concerned, with respect to that patient who is on the machine, unfortunately, the law does not give you leeway to decide. You, as the carer, it's not something you, because if you are to do that, then our law proceeds in a very interesting way. There's a difference between inaction and action. We call it malfeasance and nonfeasance.
Yes.
Malfeasance is where you take the action that then results into something. And then there's nonfeasance, where you decide not to do anything, and then everything that just takes its own course and the same result happens. And so the question would be, when the patient, and some relatives might have issues, and
Yes.
they choose to use that as a reason to to try to deal with their situation. And so if it is argued that this person, even though they were brain dead and all that, the heart was there, but you see, the law looks at them, they're still alive.
Yes.
But clinically,
Clinically, they're dead.
They're gone.
Yes.
So unfortunately, our law does not allow us to take that step. We have not developed any framework that will allow a hospital, a carer, a healthcare provider to take that kind of step.
What about? I was just going to pick the non-efficiency part of it. What if we decide to do nothing? Is that legal?
Yes, good question. Because the question then would be, if you were to do something, look at the flip side. If you are to do something, one, what would it be, and what would be the result? Are you likely to improve some interventions may be intrusive, quite intrusive, and you would think that perhaps even for the benefit of the patient, I mean, really, there's nothing that that intervention is going to help with. And so the question would be, what would a reasonable healthcare provider under those circumstances do? You are the professional. From your clinical judgment, it is very clear that whatever you do for this patient, the outcome is not likely to be positive. They're technically gone. And so what I've seen some doctors do is to take the safe route. You sit by, let nature take its course, because that is the safer route than taking the step and switching off the machines.
Yeah. All right. What if, because I know, again, what if the family, that's actually something else. Is it legal, now that you're saying that we cannot take off a patient off a machine? What if the family signs asking us to take off the patient from the machine? Are we legally covered by the documents the relative signs? Yeah. And in that discussion also, then we can also discuss the legality of do not resuscitate orders.
Okay. Okay. Again, unlike other jurisdictions where end of life issues have actually been legislated very well, these circumstances have been anticipated. Unfortunately for our doctors, our doctors really tread on very thin ice. Yeah, it depends on the relatives, for example. They may decide, I don't know whether they can sign, legally speaking, because I don't know whether you can sign and say, take off, switch off the machine. If a family signs and sort of authorizes the doctor to take off the machine, there'll be very little legal protection.
Okay.
Very little legal protection. You would have to depend on the goodwill of that family. Maybe, they're not, they sign that document. They want that kind of outcome and so on. But if you get situations where you get some overzealous prosecutors and so on, they might pick that up because there are serious loopholes there.
Yes.
Because it would be you conspired to cause the death of this person.
Yes.
So when it comes to those documents where relatives sign up and tell you, okay, you go ahead and so on, I would urge a bit of caution in those circumstances. And perhaps if you have a hospital establishment where there is a legal team, you would want to involve the legal team of your hospital to make those kinds of determinations. Because again, the problem with us is that it is very episodic and on an ad hoc basis, unlike other jurisdictions.
Well, actually, funny enough, I mean, and that's why, as I say, it's something that happens quite commonly. A lot of decisions are being made. It's actually like why we had to have this discussion because a lot of these discussions do happen, but they happen from the aspects of the law, an illegal way, and it's good to know that you should be involving the legal departments of your facilities when you are coming up with some of these decisions. I think that's the very best advice in this discussion because, yes, you could easily expose yourself to a lot of litigation. Talking of litigation, we are all encouraged to take this indemnity cover. Part of us feel like, I mean, that's just insurance is making money out of us. But what's the limit of these indemnity covers that healthcare providers take? Are we indemnified from everything, or what aspects are we indemnified from? I don't know that you have any experience with that.
Okay, yeah. We also do professional indemnity.
Yes.
But the professional indemnity, the advantage it gives you is that it just covers the cost. It just covers the cost in the event there is
legal costs.
The legal costs in the sense of damages that may be awarded against you, but it does not cover you from liability.
Going to jail.
It doesn't cover you from liability. It doesn't. It just, if in the event a patient or their family raises a complaint in the context of medical negligence,
yes,
you would still have to go through the legal processes, and if the court finds you liable to pay compensation, then now that is when the insurance kicks in and pays on your behalf. Otherwise, in terms of liability, in terms of liability, bado iko kwa mkono yako.
Bado unaenda jela peke yako. All right, interesting. Okay, I know there's some questions which I know the answers to, and I'll let you just discuss quickly around the Health Act. So the two questions I know that in the Health Act is, under the law, is any doctor, all doctors registered in Kenya obliged to offer emergency care? Or is it there is sole reserve of those who are trained in emergency care? And I think these questions come from, I know in the Health Act it says, as a healthcare provider, you must provide emergency care. But what happens if I am not a trained emergency care provider? I'm a healthcare provider. I'm not a trained emergency care provider. And I provide care and this patient dies because the care I provided was substandard. Okay.
Let me respond to that from 2 points of view. Number one, under the Health Act, the provision of emergency care is mandatory. But then there's a rider to that. Number one, it has to be within the context of your abilities, and abilities is in terms of your expertise and also in terms of the resources that you have, the resources in terms of equipment, because certain situations may present that your establishment is not equipped to deal with. And so what the law requires is that you provide only the basic life-sustaining intervention. So that anything that requires specialist care, then you refer. Okay, so the intervention should be one to save life. Beyond that, if you can't provide anything beyond that, then you
extra day of per diem because you didn't get.
Sorry,
Lily,
Lily, mute. Lily, mute. Sorry.
Yeah.
I see. So you'll be given, and why you given an extra?
Let me find. Oh, I think she's muted. Yes, go ahead.
Yeah. So, so beyond your level of expertise, you have to refer that patient to the next step.
Okay, so that means yes, you're obliged to provide emergency care within the spectrum of your expertise, or at least to the best of your expertise. And then if you can't, after that, you're supposed to refer them to more professional services, I guess.
Yes.
Okay, good. All right. So that I think answers the questions. What happens? So what if, so I guess I would not be sued if I'm not a trained provider and I did my best based on my expertise and the patient died, then I would not be held liable for that.
No. You wouldn't be held liable. I mean, again, it's all about, it depends on the circumstances. The issue would be, did you do your best under the circumstances? Did you render did you exercise the skill that was expected of you under the circumstances? Again, it depends on the circumstances. It is there's no hard and fast rule.
Fast rule on that one.
Yeah.
All right. Again, also as I said, in the Health Act, the issue of so if a hospital has a protocol that demands payment fast before providing emergency care, as a healthcare provider, what are you supposed to do? Because yes, you need to provide emergency care, but the hospital limits your actions by insisting on payment fast. So what are you supposed to do in that situation? Where
the hospital insists on payment fast.
Yes, so the hospital policy is money fast, care later. Yes. So your hands are tied because then you can't really intervene because someone has to pay first.
Yes. Okay. Yeah. And you are the doctor, for example, on duty, whatever.
You're the doctor or nurse on duty. Emergency has come in, but you're told categorically you should not do anything until the relatives pay, and the relatives can't pay, and you can watch this, and you're watching this patient deteriorate. What are you supposed to what? Where are you here? Because yes, you can go against the hospital, and can you be fired and legally fired for that, or should you be or you can sit back and then patient dies, which then also what that whole situation? Maybe you can help us.
Okay, I think the first thing to say is that the law frowns upon, if you look at the Health Act, and also in the context of the Constitution, the bit about money first and care later, that has been litigated. If you remember the case of what's his name? I'm forgetting the name. This famous 50, what is it, minutes?
18 hours. Alex Madaga.
Yeah.
Madaga, yes.
Alex Madaga. Yeah. When it went to the board was very clear that you provide the care first. Forget about payment and so on. So at least insofar as the establishment is concerned, where they insist on payment first and care later, and then the patient suffers further injury, or worst case scenario, the patient dies, then the liability is on the hospital. It is not on you, because you are not the decision maker. There's a clear policy that tells you not to act. And that is why if you look at the case of Alex Madaga, the individual doctors themselves, or even the nurses or the care personnel themselves, were not liable. It was the establishments themselves that were liable. So I guess when you're faced with that scenario, it has to be your own decision or your own personal decision. Do you want to risk your job and be safer morally, you know, in the sense that you save the life and so on? But then again, if it so happened that you intervened minus the payment and against the policy of the hospital, you know, and then you suffer consequences, for example, you are discharged from employment, then you are covered by the law, because that would not be a ground for dismissal. It cannot be a disciplinary issue, especially in the sense that, number one, the Constitution guarantees the right to emergency medical treatment, and number two, under the Health Act, you are obligated to intervene as an individual, a healthcare provider. And so, where a situation arises where you have intervened and your employer is telling you, you know, and they use that as a ground to terminate your services, then that will be illegal to do so.
Okay, good. So then at least you can actually go and sue maybe the hospital for wrongful dismissal.
Yes, absolutely.
All right. Good question. Good. Really, this is very interesting discussion. Remember, you can type your questions in the chat or in the Q&A section and we'll answer them. Now, there are these forms we normally have patients sign. They're called Living Against Medical Advice or Against Medical Advice. Are these forms legal in Kenya? So patients, this is not a child, for example, an adult who signs a form that say that they do not want treatment, and they sign a form saying, I don't want treatment, and they go and die. Does that form indemnify you as a healthcare provider or you as a facility against litigation?
Yes, it is. I've always seen that as a clever way, in a very innovative way to cover yourself from liability. Number one, this is a patient who is they have a full mental capacity to decide whether they want the intervention or not. And under the law, the rule is that every adult patient of sound mind can decide whether or not to undergo treatment. And that is, you know, they can decide. So if against your advice, they choose to walk away, the innovative way is to have them sign that you advised them and they chose not to follow your advice. So those are very legal documents. And in the event the patient goes and suffers some injury, they cannot come back and successfully maintain any claim against you. So yeah, those are good documents, and I would urge all of us who find ourselves in those situations to sign to have those kinds of documents and have those kinds of patients sign those documents, because it covers you.
Yes. Actually, one of the things, especially one of the issues I normally have and the discussion we have again with our team is that issue of competent adult. Now, if it's a guy who's straight from the bar, because normally they'll be drinking in the weekend, and then they show up in the department after some fight, and of course they normally will insist on going home. And you look at this guy, you're like, yeah, you're not in a situation you should go home. Maybe there's some injury or something, or we need to admit you for something, or we need to do some tests on you. A drunk person sign this form. Are they considered competent?
Okay, drunk persons who are suffering from mental incapacity, unconscious patients, so the question is, depending on the circumstances, are they in a position to make a decision that can be said to be sound at that particular moment? If they are drunk, it is possible that they do not have full control of their mental faculties. So again, it's a question of degrees. How drunk are they? Do they appear like they know what they're doing and so on? So again, as I said, it's a question of degrees. if you, from your judgment, they appear not to be in a position to make sound decisions, then there may be an issue there. And so you can make that determination under the circumstances.
Circumstances.
Yeah.
All right. Now, we discussed earlier about kids and being able to override the parents' decisions where you feel that the child's health will be in danger if you don't intervene. What about adults? How much leeway as a healthcare provider do you get to override an adult who's refusing treatment, but you think this treatment is life-saving, or an adult whose relatives are refusing treatment, and these people are not keen on signing this against medical advice forms and stuff? Like, what leeway do you have to override autonomy, patient's own decisions or next of kin's decisions around the patient's care?
Mhm. Okay, the general rule under common law is this, that just as an adult patient with full control over their mental condition is perfectly free to accept or to decline treatment. And that's an absolute, as long as they are in, their mental condition is okay, they're sentient and all that. And the courts have said that it does not matter that the reason is rational, irrational, it is reasonable, unreasonable, it makes sense, it doesn't make sense. As long as they are an adult patient who understands the consequences of their decision. In other words, they can make rational decisions. So if they choose that they do not, a patient has come in, broken hands and whatnot, and they decide, maybe I can do best with a bone setter in the village.
Yes.
It's none of your business. I think the best you can do is to cover yourself with that, that document where you require them to sign that they are waiving any claim in the event anything happens, and they are acknowledging that you have advised them appropriately and they have chosen not to. So as long as the patient is sentient, is an adult person and all that. But now, so the exceptions are where, for example, the patient is unconscious and it's an emergency situation. Then you have to intervene.
You have to intervene.
Yes, the patient is unconscious, it's an emergency where, again, failure to intervene is likely to jeopardize the life or the limb of the patient. So that is one exception. The other exception is where the patient, as I said, is not in a position to understand the consequences of their refusal for intervention. Let's say, for example, to use not a very good term, unsound mind. It's not a very good term. The law has changed now. They don't use those words. Where from a judgment, you feel like this patient is suffering from certain mental incapacity, and so they cannot make that decision. Number three is where the patient is, say, a minor who is incapable of understanding the consequences of their refusal. Then you can intervene, although it's not for all minors. Again, minority depends on the level of their mental capacities. Minority is relative, because some minors are of such a mental disposition that they can decide, they can agree, they can understand the consequences of their decisions. And so
just actually on that question, can a minor override their parent in a healthcare setting, emergency care setting?
Okay, yeah, that's a good one. So as I said, minority is would be relative. The law looks at there's something we call the Gillick competency, or the evolving capacities of the minor. So that under the law, a minor is any person who is under 18. So that gives you 17 years and 360 days all the way to 0 years.
Yes.
But you see, the minor of 5 years is not necessarily the same as the minor of 17 years.
Yes.
So there are certain circumstances where a minor, depending on on the assessment of the situation, there are certain circumstances where a minor can actually decide and even override the refusal of a parent in matters of healthcare. I know this is something that has been very touchy in Kenya, but in other jurisdictions, the courts have said, depending on the evolving capacities of the minor, then there are certain circumstances where if the minor can be shown to understand, but a minor above certain age, I guess from 12 on, onwards.
Yes.
And so if it can be shown that a minor of a certain age can actually understand the consequences of their decision or indecision, then there's certain instances where their decision can actually override that of the parent, and especially if the decision of the parent or the indecision of the parent is not in the best interest of that minor.
Yes.
And the minor is actually making a decision that is in his or her own best interest.
Okay, so it's very interesting, because I think in South Africa, I remember 12 was a cutoff. I mean, a 12-year-old could consent to surgery without the parents' consent, and a couple of other things that they could consent to. So I think even nationally, there was a lot of, they had reduced it to around 12 years of age.
Yeah.
Which is good. So thank you very much for those questions. So some of your questions have already been answered indirectly, so I'm just going through them. I think this issue of Jehovah's Witness and blood is something that will always be a discussion internationally, not just even in Kenya. But I think, like you said, it's if the patient is on sound mind, then they have to make the decision. If not, you as a healthcare provider, can you override actually where religion is involved here actually? Can you, assuming this patient cannot make that decision by themselves, they're Jehovah's Witness, they're against blood, but the patient is mentally, because of their condition, unable to make that decision. The relatives are here saying, do not give blood. You as a healthcare provider know that blood will save this patient. So in that situation, what do you do? Do you straight ahead, go ahead and give the blood?
Yeah, there's a famous case, we call it the Jehovah's Witness case. It was decided in the UK. In this case, the patient came in, she was unconscious. Then from the clinical situation, it was very clear that she needed blood because I think she was pregnant, she was losing blood, and unless there was immediate intervention, then the outcome was obvious. But now the relatives had refused. They said, no, we are Jehovah's Witness, and they produced that card, do not, no blood transfusion. And so the court, when the blood was transfused, the patient was saved, they come out, healthy and all that. Then they ran to court and they say, but you see, from, it was very clear that we did not consent to this. But the court said, but you see, under the circumstances, the doctor had no choice, because if the doctor failed to intervene, then this patient was going to die. But most importantly, also, the patient herself, the court took the view that her condition was such that it interfered with her decision-making process, so that her mind was not sort of in such a position as to appreciate the consequences of a refusal for blood transfusion. So again, it depends on the circumstances. If the patient is, sentient, conscious, whatnot, mentally competent, and they say no, you just have to leave it at that and have them sign that indemnity, that form.
Yes.
But where you make a clinical judgment, and it looks like the patient, perhaps because of their condition, they are not in a position to make a sound judgment, then you may have to you actually defer to the clinical judgment. And the law will actually protect those kinds of interventions. The litigation is there. It's only that it has not happened in Kenya, but in the UK, there's been a lot of that. And the doctors,
Interesting. That is a very interesting question. And I think I've seen this happen. In an emergency, patient is unconscious, needs urgent surgery. Is a thumbprint valid? So I've seen this happen in hospital where you're taking the thumbprint of an unconscious patient. I don't even know who, but yes. Yeah.
That is a clever way of protecting yourself, but
That's cool.
Where is it? It's not. The doctor is actually protected under those circumstances because the patient is unconscious. It's an emergency situation, so you can't wait. You can't wait.
Yeah. So
I think that the thumbprint is an overkill, if you ask me, because already there's protection in the first instance. This person is unconscious. They are in an emergency situation. If you don't intervene, serious consequences to the life of the patient will likely result.
Yes. So I think, let's not be taking thumbprints for unconscious patients. If it's an emergency, it's an emergency.
Yes.
Then you have to intervene. You don't have to take big thing. I've actually seen that happen. Yes. Yes, I think, let me just see which other questions. Just about CPR, like, do we, assumingly, so this is actually something that also happens. Patient is terminally ill and they're in hospital, and this is more or less end of life, give or take. And I know you mentioned it's a bit gray area. And they go into cardiac arrest, so they pretty much stop breathing and heart stop beating. As a doctor, can you withhold resuscitation based on the circumstances? Assume there's no paperwork to support this. Like there's no, as you said, even the DNR forms are not really there legally. But can you be sued for not providing that resuscitation from the perspective that this was a terminal case? There's nothing here. Can you be held liable if you do not resuscitate this patient?
Okay. Good question. Let me answer that by saying this. I saw there was another question relating to whether you are bound to intervene and so on. Huh? Now,
Yes.
Under the law of tort, there is no obligation to save a person in peril. There is no legal obligation.
We need to clarify that. There is no.
There is no legal obligation to save a person in danger. Okay, so that is a general principle, but now there are exceptions.
Okay.
There are exceptions. Unless there is, number one, unless there's some sort of relationship, such as a doctor-patient relationship, or number two, where there's you undertake, for example, I saw someone asking a question. You are a doctor on a flight.
Yes. So that, yeah.
Yeah, someone, some emergency arises, and then they ask, is there a doctor on board? The way they usually ask in the movies. I don't know whether they ask that in real life.
Yes.
Yeah, you can actually choose to keep quiet, and and not
All
do
right.
anything. Yeah, am I saying that is morally right? Morally, it is not right. It perhaps is not right, but legally, the law will not hold you to account if you choose not to intervene. Because the law, remember the distinction I made earlier on, the law only binds you for a wrong, and a wrong that only arises because of an act of intervention. Non-intervention generally does not, non-intervention generally does not raise a legal obligation in the context of negligence.
So doing nothing doesn't put you at like, yeah, you're
Yeah,
safe.
yes, unless, as I said, unless there's some form of relationship like doctor-patient relationship, where you are
Okay.
now bound to intervene. For example, this person is in your hospital. They are your patients. So already
Okay.
there's both a contractual relationship and a tort, we call it tort relationship,
Mhm.
So there you're bound to intervene and so on. So that is in the context of tort, and also in the context of the situation where a patient shows up in your establishment, you're a doctor, it is an emergency situation, of course, you are bound to intervene. So they are very...
Out here on the streets, we are not bound to intervene.
Oh, you might be wearing your lab coat and your stethoscope, whistling. It is something, we call it the example that we give is if you're a good reader of the Bible, the Good Samaritan.
Yes.
In the Bible, the Good Samaritan saved someone who had been attacked and so on. So the question that we ask is, what if this Good Samaritan chose not to intervene? Now, in the law, he will not be liable, but morally, perhaps he would be, responsible. But the moment you choose to intervene, then you must intervene in a way that you do not jeopardize the life or limb of the patient.
Okay. So that is a whole new discussion. So
Yes.
if you do nothing, so this is not on the streets, let's move away from the contractual obligation. So if you're out on the streets and you come across maybe an accident victim and you try and help them, okay? So if you did nothing, you're fine. No one would ask you any questions. If you try and help them and maybe you do something that obviously compromises their care, or leads them to die for some reason, or can be attributed to their death,
Yes.
then you can be sued for this?
Yes, and you'll be held liable. As long as, if you choose to intervene, it is called undertaking. It's an exception. You undertook. And the reason you undertook is because you thought you had the skills to intervene in a helpful way. And so once you decide to lift a finger, then you must lift that finger in such a way that you do not compromise the life or limb of the patient or of that person. If you do, then you will incur liability, and you can actually be sued because you offered.
Yeah. Because you offered to help. So and this applies, I guess, also to, does this also apply to non-healthcare providers? Yes,
it applies to everyone. That is a general rule in the law of negligence. If you are maybe you went out in a hotel and you saw someone jump into the pool and they don't know how to swim, they're drowning, and you choose not to intervene, God will punish you, yes, but the law will not.
But if you try to intervene and something happens, then the law
could jump into the pool and I don't know how you can I don't know
You,
what it
you
is.
help the patient to drown further somehow. I
Yes.
don't know.
If
And
you
you are
want
like,
to- Yes, you get it.
yo,
Yes.
okay, that's interesting to know. All right, let's switch gears a bit. Rape and gunshots. So the medical legal aspects, especially. Are we, as healthcare providers, obliged to report rape cases to the police or gunshot cases to the police?
Yes, that's a good question. There isn't any statutory obligation that I'm aware of that obliges you to report either sexual assault or say gunshot wounds and so on. I don't think if you fail to do that, I don't think there will be any successful prosecution. There's no statutory obligation, as it were. But what I know is that this has been a practice. It has been a practice that healthcare providers who encounter these kinds of situations will take the next step and inform the authorities, and then the authorities will. And how I look at those are obligations of a good citizen. But in the event that there either an oversight or a failure to report under those circumstances, there is no statutory obligation. Perhaps it may arise as an issue of professional misconduct. I don't know, for which action can be taken under the council, under the framework of the council. But in terms of a crime that is being committed, because the only thing you have witnessed is a victim who has presented themselves and said that I have been assaulted. You are not there witnessing the assault itself. If you are there witnessing the assault and you fail to report it, then that would raise other things. But in a professional care setting where someone comes and says this and this and that has happened to me, or someone has come with a gunshot wound, what crime is it that you'll be reporting? There's no, as I said, there's no statutory framework that requires those kinds of things. These are just obligations of a good citizen.
Just under the same obligations of a good citizen, because even us healthcare providers want to be good citizens, at which point would you be breaching doctor-patient confidentiality by reporting some of these cases to the police?
Okay. Now, doctor-patient confidentiality is an interesting area. Number one, it is premised on the Constitution, statutory law, as well as cases decided by the courts. We call them common law. Now, patient confidentiality is not absolute. There are instances where there are exceptions. And exceptions would arise, for example, where the law compels the disclosure of certain information. That is one. Number two, it is possible that disclosure of that patient's information is in the interest of that patient. Okay, so under those instances, there will be some exception. The third exception is where the disclosure is in the interest of the public.
Okay.
So the rule as to confidentiality is not absolute. There are exceptions. Again, it depends on the circumstances of the case.
So it's either to the benefit of the patient, the benefit of the community, and the third one was?
Where the law compels you
to
okay. disclose. Yes.
All right. Yes, quick one. Law of torts, does attendance to any facility for an emergency or not carry an implied contract to pay the prescribed fees?
Okay, interesting. For an emergency situation?
Let's look at both emergency and non-emergency.
Okay. Okay. Of course. I mean, you've gone to, let's say it's a private healthcare, or even a public healthcare setting, because costs arise in all those settings. The moment you present yourself to the establishment or to the healthcare provider, and you're quite aware that these are establishments that charge certain costs and so on. Yes, the fact that you present yourself there as a patient, there's an implication that you are actually agreeing that you will pay. That is under normal circumstances, okay?
Yes.
Where non-emergency under normal circumstances.
Yes.
Now, so here's the thing. When it comes to an emergency situation, the law doesn't say that the patient should not pay. It doesn't say that. What it says is that the intervention cannot be denied on the basis that the patient has not paid first.
Okay.
So in the long run, it is known that if the patient comes and gets those services, they have to pay for them.
Yes.
It's only that if it is an emergency, as the provider, you cannot sit back and say, you know what, I am not so sure these guys will be able to raise my 100,000 deposit. And so until my 100,000 deposit is paid, then I cannot render basic life-saving intervention. Then that would be a problem. Remember that, and the courts have been very consistent on this issue. It's not a question of the courts encouraging people getting services for free. That doesn't work like that. The courts are alive to the fact that these establishments incur certain costs. And if they are private healthcare settings, they have that goal to make profits and so on, which is a very legitimate goal. And the courts do not frown upon that. And so that if a patient comes and they get those services, what the courts are saying is that as a provider, look for other ways of getting your money. Those other ways may be limited, they may not be very effective and so on, but you cannot, refuse to render a basic life-sustaining, life-saving intervention on the ground that you should first be paid.
Yeah, I think that's clear. The other part of it is, okay, so what if the hospital provides the care and then now is demanding payment? So you're stable now, you're not in any danger, you still don't have money, but the hospital now is detaining you because you are not paying for the services you received. Is that legal? Yes, it's a common case.
Yeah, happens daily in spite
Yes.
of and again, our courts have said again and again and again, and the Constitution is also very clear, international law is very clear. You cannot detain someone on account of a debt. You can't. But it's something that happens, despite the fact that the courts have stated it clearly. And again, I should emphasize, the courts are not saying that you cannot get your pound of flesh. I don't know who was that. You have to get your money. If you set up a business, it's a business and you have to get your money. The court is saying it's only that you can't get your money by detaining this patient. So what I've seen some of my clients do is that if it appears that the family may not raise the funds that or the fees, they convince them to bring over their titles, other properties, and sign them over to the as security for the debt. Yeah. It's a clever way, a very innovative way of protecting yourself in terms of losses and so on. you may get your money, you may not get it. In the same way that you may not get it when you detain the patient, but it is not legal to detain a patient on account of unpaid fees.
Because I think that's something that is always an issue. In emergency care, we rely a lot on verbal consent because things are rushing and we don't have time for people to sign for things. And actually, yeah, maybe that's also the next question is, because a lot of the interventions are potentially life-saving. How valid is verbal consent, or do we need to get a written consent from anything? Or is this just implied that in an emergency, it's the consent is there? I don't know.
Oh yeah, that's a good one. The law, insofar as the law is concerned, consent has to be there. But the law does not say that the consent has to be written. It can be, as long as the consent is expressed. Expressed can be written or expressed in verbal form. What I tell my clients usually is have someone else there.
Okay.
A witness, and then
Yes.
you can actually, what you can do is that you can design, because I've designed some consent forms where it is an emergency situation, the patient cannot write and so on. And then the patient is, whatever intervention is explained and they agree, then that is reduced into writing and the witness signs at that very moment that it is, the consent is being given. So it's a question of protecting yourself. It
Okay,
doesn't
so-
have to be written, it can be spoken.
Okay, so it can be verbal consent, but again, has to be, if you are concerned enough to just get a witness, someone to countersign that.
Yes.
I'm concerned by the amount of questions around kids. I'm not sure what is happening, but child services, how effective is our child services system in the country? Because I'm seeing a lot of questions around the care of kids, especially where you're worried about child abuse. Parents are not consenting to things, or parents are refusing for care for this child. Child services, do we call them? Where do they come in?
Oh, yes. Now, the Department of Children's Services has been established under the Children's Act. So it is the go-to department on any issue relating to children. In fact, it's always good to consult them. If you should, in your establishment, you should probably have the numbers of all the children's officers around you, so that you can always, because they are mandated to discuss these things and they're mandated to make decisions. So children's department is very critical. So if you're able to establish a relationship with them, then it is something that I would advise that if you're running an institution, please perhaps even have a children's desk, a children's officer who can liaise with the children's officers appointed under the Act. Now, are they effective? As is any government office, understaffed, under-resourced, but you can make use of them. Make use of them.
Yeah.
They come in very handy.
Yeah, I see. I was just quickly checking if we have some child hotlines. And I'll just quickly investigate a bit more. And I will add this number to our casualty app for just the child's hotlines once I find out the correct line. I see there's a 116, but I'll just find out. I think it's something that we probably should have readily available, as we have ambulance lines and the rest. So very good. All right. I think a lot of the questions have been answered. A lot of them were repeating. If there are any other questions, I think the key things that are coming out from this discussion, number one, of course, is the issue of competent adults. And so if there's an adult that's competent enough, they should be making their own decisions. Where the adult or child or person is not competent, then you as a healthcare provider should be making the decisions in the best interest of the patient. And this then overrides other people's discussions, I guess. So you should always act in the best interest of the patient. But just keen to hear is that the moment you intervene, especially in a non-healthcare setting or where you're not obliged, then if you intervene, yes, you should be intervening, which is good morally okay. But just know then you are opening yourself to potential liability in case something would go wrong. I see someone in the comments saying his experience with the child officers has been quite good and sorted a lot of cases for them. So yes, the department does work. So always feel free to reach out to the child department. I believe we've answered. I think there's only one more question. Maybe I'll ask Maurice when he's back on. I can see he's just quickly stepped up.
Yeah.
Yes. Is there any, there's no, the living against medical advice or any of these forms, is there any legal guidance and maybe something, I don't know, the LSK or someone as in should come up with, are there any standard forms we should have been signed, or what content should be on these forms?
Okay, there's no standard form. In fact, that is one of the big problems facing a lot of hospital institutions. Now, what happens is that they have had to rely, like I know, the one that I know here, MTRH, their legal department has had to design the forms. So they have their own internal forms. So there's no legal standard, but the content should be, number one, of course, provide for space to indicate the condition that the patient is in. For example, what is their condition? What is their ailment? Were they in an accident? So you describe, and then you must describe that you have suggested a particular regimen of intervention. Then provide for a place to indicate that they have declined, and then they sign. So it's a question of capturing what was the issue at hand, what was the intervention that was proposed, and what was the outcome. And it must be very clear that this patient actually declined, and then they sign, and you must have a witness. It's good, it's always good to have a witness, countersign, and that's it. So essentially, it's just the content. Just whatever document, just ensure that it covers those 4 areas.
Awesome. And this is a question here actually just been put in, which is interesting. If a patient comes to the hospital and they choose to leave without or before being attended, and something happens to them after leaving, can they hold the facility liable? Maybe they came and they waited for such a long time. Actually, maybe the two scenarios. So the patient came and waited such a long time that their health deteriorated and they suffered some consequence because they could not get to see the doctor on time, or they came, waited for some time, got tired, left, and something happened to them. Where does liability stand on this?
Okay, yeah, those are interesting ones. Now, again, it's going to be, for example, in the first scenario, we have to determine what was the expected reaction time. What would be the reasonable reaction time in this particular healthcare setting? And what is it that caused the delay in the intervention? Some places are pretty busy, And the delay in the intervention can be attributed to something that is not deliberate or negligent. So under those circumstances, then liability cannot lie on the establishment because there are mitigating factors. There are things that prevent it. Let's say a patient comes to hospital suffering from certain conditions, and then an emergency happens where a ton of other patients who require, immediate interventions coming. I mean, those can be explained. The facts of the case are that this patient could not be reached, and so there are mitigating factors. And so the question is, what is it that caused the delay? Is it something that is deliberate? Was it negligent? Or is it something that can be explained based on the circumstances? Maybe you don't have the personnel, you don't have the equipment to deal with this situation. Then the blame cannot lie on the institution. The second scenario is where the patient simply comes, they look around and then they decide, no, I don't want to sit here, let me go on. And then something happens. The patient did not bring themselves within the healthcare relationship. They did not establish a relationship.
Okay.
And so they moved out based on their own volition. So the establishment has got nothing to do with it. So if they go away and they suffer, then again, the question is who caused, that injury? It's not the institution.
Actually, one of the other questions on this would be around, this is, I actually say someone said, there's quote said, suing the government in Kenya is like suing God. You might win the case and then. So the question would be, what if you go to a facility and you do not get the prescribed or best emergency care because of lack of resources, for example, or lack of trained healthcare providers, and the care provided is substandard? Where does liability lie? Like, does the liability lie with the institution or the healthcare provider? So, for example, I'll give a good example. A patient comes in and I need to put a tube down their throat to help them breathe, but I do not have the tools and the equipment to help this patient that way. And of course, yes, we always say refer, but as we are trying to figure that out, this patient passes on purely because I don't have the right tools for this procedure. Am I liable because I did not, had I put that tube, that patient probably would have survived. So where does liability lie here?
Yeah, okay. Again, good question. So I think the answer to that is to answer the question, who is at fault?
Yes.
Who is at fault in this instance? The healthcare provider was available, willing to intervene, but no tools whatsoever. So then the next question would be, if the patient, for example, dies because of the absence of tools, remember, under the Constitution, the right to health is an obligation on the part of the state. So it is the state that must provide these tools. The right to health is very broad. It includes even the provision of those tools, not just the creation of conditions to enable people to be healthy, but the government is obliged not only to build facilities, but also to equip those facilities. And remember, now this obligation is split between the national government and the county government, but regardless of the setting, the state bears that ultimate responsibility. So that if people suffer consequences because tools have not been provided, then it is the state that bears the responsibility. Now, of course, the state bears the responsibility. The question is, if you are to sue, you get judgment. You will sue, you will get your judgment. Will you recover? That's a wholly different questions altogether.
Right. And yeah, because I guess in this case, you'd be suing the county government because the county government that is supposed to be providing the healthcare.
Yes.
Yes. Interest. So at least the liability, the issue would be the institution, so not your availability.
No.
Yes, so that would be, yeah, that'll be interesting discussion. But I think yes, there are instances where you want to intervene, but you don't have the right tools. And it's a discussion, I guess, to also have with the county governments. But I think I'm not seeing any additional questions. I feel most have been answered. Thank you very much. It's been really a great discussion. And I see a lot of people are appreciating the questions, the answers they've gotten. I think most people are now really dancing on going to jail somewhere there. But I think just to reemphasize on, for a child, if the parents are not making the right decision, you as a healthcare provider are protected. You need to make the right decision for the child based on the best interest of the child, and you are legally covered for that. And the same applies to the adult situations, where the adults themselves cannot. If the adult can make a decision, then that's their decision. If they can't, then always make best decision based on the best interest of the patient. And I think as emergency care providers, that's our main thing, is mainly save lives, and that's the main thing that we really go to. And I'll just tell Maurice, maybe he can put somewhere his law firm for those who need emergency medical care, legal. He can put it in the chat. So in case you have any legal, yes, if you ever find yourself in a tight spot as an emergency care provider, I know I would call Maurice. So I think he'll share his contact somewhere in the chat there. Yes, it's Kai Odur and Company Advocates. But thank you very much, Maurice, for spending the evening with us. I think we really appreciated this. And it's always nice when we call upon you to come and join us. So thank you very much for that.
Absolutely. Anytime.
Yes.
It was great.
Yes. The contacts on the chat there. So from Medical Legal, I think you may need also to speak to your organizations about, as you said, either legal department, but also looking at coming up with appropriate paperwork in terms of just covering yourself. But also remember, if you're signing any document where you're either terminating care or withdrawing care, please make sure a lawyer is involved to cover yourself. So just signing documents by yourselves, that doesn't cover you. Where we're withdrawing, our Kenyan law doesn't allow you to withdraw care or terminate care for a patient. Yes, so just if there are any documents being signed, make sure there's a lawyer involved. With that, we've come to the end of this exciting session. Thank you very much, everyone, for joining us.